Lino Aguilar versus Western Digital, Michael Valdez was the name of the case. It happened out in Santa Clara County. Lino Aguilar was 74 years old at the time and worked for a janitorial company called GCS Services. Western Digital is a huge tech company down in the Silicon Valley, and San Jose itself actually has a large, sprawling campus with lots of buildings.
Lino's job was to go around the facility and make sure that all of the buildings were clean. He was a janitorial supervisor. So on the date of the incident, as he did every other day, he went to a building on campus to check on the work. And as he was exiting, he was struck by a golf cart that was being driven on a sidewalk on the campus. Now, Lino didn't know that the golf cart was being driven on the sidewalk. And the reason why he didn't know that is because he'd never seen that happen before. It was against the rules for Western Digital and its employees to operate a golf cart on the sidewalk. The driver of the golf cart, his name was Michael Valdez. He worked for Western Digital and was a maintenance technician there.
The Western Digital employee admitted that he was looking at his cell phone at the time, was not paying attention, never saw Lino until after he hit him. And so the case was resulted in catastrophic injuries to Lino, orthopedic injuries. It literally injured from head to toe. Fortunately, no brain injury, no spine injury, but broke several bones and ended up spending 4.5 months either in a hospital or skilled nursing facility, and has undergone 7 surgeries, has 2 more scheduled at the time of the trial, and so was seriously and catastrophically injured. A couple of days before trial, they admitted liability, but we were prepared with a liability presentation. Of course, they wanted to argue comparative fault, and we were prepared to deal with that. However, just a couple of days before trial, they admitted liability, admitted that they were solely responsible for his injuries. So we made the decision to waive economic damages and focus completely on non-economic damages, which was a challenge. However, we had each of the 10 elements of non-economic damages in that 3905 jury instruction. He had each and every one of those 10 elements, and we had evidence of those, whether it was a picture, whether it was a surgery, whether it was a medical timeline that Cogent did that showed all of his medical appointments to show inconvenience. So we had great pieces of evidence for each and every one of those 10 elements to show the jury how they should compensate him, because the jury instruction is you must compensate the plaintiff if he has proven each of these elements. And ultimately, we're successful in persuading them. The defense, they initially countered with a CCP 998 of 2.5, and they went up to about $3 million just before trial. But we said, hey, like we said in the letter, we're not returning to that 5.5. That's off the table. And negotiations broke down very quickly, and we went off to trial. I think it was important for this family to be acknowledged that just because someone is 78 years old doesn't mean that his or her injuries should be minimized. I think this is a real acknowledgement of the jury of someone who is older in life, but still has a lot of life to live, but the quality has been so dramatically impaired. I think the jury really understood that, and I think that we should, as a community of trial lawyers, reconsider our approach to damages for older folks.
My name is Christian Jagusch. I'm the medical negligence counsel at Walker, Melodia, Kelly, and Schomburg. Well, I've always said one of the struggles as a scientist, because I tell people I'm actually a doctor that went to law school, not a lawyer with a medical degree, was to explain simple things like, well, why is the sky blue? Well, I can tell you why it's blue, but the legal profession wants to explain to you why it's not blue.
Christian Jagusch, who is the doctor lawyer in my firm, met these clients and said, I really think you should meet with them. And we were fully in the beginning part of the pandemic, and we weren't able to meet them except by video conference, by Zoom. And what was so hard about that in a case like this, where it was a delayed diagnosis of stroke, that our client really couldn't speak. He had what is diagnosed as expressive aphasia. And so the thoughts in his mind were not able to come out of his lips. We knew it was going to be challenging. And one of the great things about having Dr. Jagusch is that he's so intimately familiar with stroke protocols and his knowledge, of course, of emergency medicine.
We're probably not surprised that the defense ran from their stroke protocols, right? Rename them algorithmic documents, educational tools, flow charts, all these different names, nursing protocols, right? When we very well know that not only do they have to be followed because it's a stroke center, it's one of the few protocols that doctors just have to follow, right? And they ran from that, and they put their own stroke neurologist up there who basically disowned these things.
Some of the challenges in this case were the nature and extent of our client's injuries. Matthew Beaver is a very young man. Today, he's only 28 years old. At the time, he was only 23. And from the outside, if you didn't try to speak to him, he looks normal. He doesn't look like he has any deficits. He doesn't look like he is disabled.
So there was no pretrial 9A. There was a pretrial offer that actually never changed throughout trial. We had gone to about 4 or 5 mediations, 3 different mediators, and made a small amount of progress. The pretrial offer was $4,250,000. Well, the actual verdict was about $15.5. After micro reduction, it was about 7.8, and we were just recently awarded costs.
And so they never made an offer of any kind that exceeded their self-insured retention. And I think for everybody who's handling a public entity case, we're mindful of how the optics might be whenever you're suing a public entity. But I think the takeaway from that was to treat your client's cases honestly. And that means recognizing the full extent of the harm and not characterizing it as something that isn't that bad, just to get the case settled with a public entity that doesn't ever want to spend their self-insured retention.
So our client, John Cooper, I think he was 70 years old at the time. This is December 24th of 2015. He was at a 24-hour fitness gym in Walnut Creek with his family, preparing to use a piece of equipment called the Technogym Excite Top Upper Body Ergometer, and he needed to adjust the seat. There's a lever underneath the seat you can pull to move the seat back. And when he pulled the handle under the seat, the entire seat quickly flew off the back of the machine completely.
He had a 2-level fusion to his neck, 1-level fusion to his lower back. The doctors thought it was likely he'd need at least 1 more surgery in the future, revision surgery, perhaps 2. Because of his age, 78, he probably was going to need care in the home.
I don't think anything about this case was normal, run-of-the-mill as litigation goes. It was filed in November of 2017. It was a Christmas Eve injury from 2015. It didn't go to trial until last year, spring of 2023. One of the reasons it took so long to get there was the extensive motion practice brought by the defendants in the case. The biggest aha moment, there were several of them, was the deposition of the defendant's person most qualified taken by Craig, Marcus Cool. He admitted several times that they did nothing to fix the problem with the defective machine. This was essentially a zero offer case. There had been a mediation where no offer was presented. The defendants could not work out between them who was responsible and who, if either of them, would pay. We served a 998, which was not responded to. That was years before trial. And then leading up to trial, there was a settlement conference at which point they offered $50,000 and nothing more.
So we got rid of those. And then it was kind of full steam ahead to then nail the defendants on liability through their person most qualified depositions. And I think the defense maybe didn't see coming. They were very focused on the fact that they were a distributor and not a manufacturer. And we were going forward on design defect. Their belief was that somehow they could create a disconnect for the jury between them as just a distributor that doesn't do any of the design piece, and this being a design case, and therefore they shouldn't be held responsible. Cooper versus Technogym USA was in Hayward, which is part of Alameda County, but not really the greatest part of Alameda County in terms of your jury pool. We had a ton of engineers. We ended up with 4 engineers on the jury, which is not exactly the way you draw it up if you're a plaintiff's lawyer. So the
plan at trial in terms of the damages that were all non-economic was trying to give the jury a sense of both the breadth and the depth of John's damages, obviously. And a big challenge we had was John, who is a very nice guy, a super hardworking guy, has lots of great qualities, but is not a good speaker. We hired Karen Jo Coonan. This was actually the last case that Karen Jo worked on before she passed away. And she told me in one conversation, Craig, John is unhelpable. This was after she'd done 3 prep sessions with him. We set out to figure out what are the realistic economic damages for John on a year-to-year basis, and decided that $1.5 million was a baseline number in terms of what he should be compensated per year. And then we asked the jury to do the hard work of figuring out what the number should be for every year above that 1.5. And ultimately, that's how they came up with their ultimate number, which was $15 million for past non-economic damages and $25 million for future, for a total of $40 million. We gave them a settlement agreement that they signed the next morning, April 4th. They signed it the next morning and then paid us. They did pay us.
Yeah.
They did pay
Case
us.
is over.
Our clients were 2 women of color attorneys for East Bay Med. Saji Pierce worked for the general counsel's department for 18 years and had a very strong reputation that she built in that time. Ariel Bland was a newer lawyer who applied for a position that she was uniquely qualified for. And at the time she applied, she was passed over by the general counsel for another female attorney who was white, and Ariel Bland is African American. Saji Pierce is South Asian American. And when she saw that and saw that Ariel was really kind of made for this job description, but was passed over for this lesser qualified white attorney, she complained. And that sort of started the series of events that really are the case. So this case was originally filed by Pamela Price, who was a veteran civil rights lawyer doing employment law. A lot of her work involved that. And she brought me in when she was campaigning to be DA of Alameda County, and she won that race. And so I handled the case on my own for some time until it was clear we were headed to trial. And then I reached out to Bernard to try the case with me.
But I knew of Bobby because we know the same people. The plaintiff employment community in California, although it's a big state, it's a very tight-knit group. And when she first started the call, she said that she started the case with Pamela Pierce. And Pamela, there's a trial college that I created. I invited her to speak at that and had heard good things before I heard her speak, and then I heard her speak. And she knows what she's doing. She's fantastic.
It was a very fact-intensive case. We had, I believe, over 20 depositions. The trial itself had over 1,200 exhibits, numerous witnesses, but the way we, were able to largely prove the case was through the defense witnesses.
So in terms of getting the value, you're basically going to ask the jury for a huge amount of money because you have all this lost time that they didn't get from their job. And then on the other hand, you have the contrast of a new employee who was barely there at the company. Why is the jury going to want to give them a lot of money for the limited time that they were there? They aren't invested in the job. It should be easy for them to find a new job. So you have these 2 plaintiffs that are on 2 different ends of the spectrum. Bobby was being strong-armed by a magistrate that thought the case had no value. The defense strategy was to basically undermine the credibility of the plaintiffs. And the way that they did it was they took the long-term employee. They said that she manipulated the new employee and that she was orchestrating everything, and that the new employee, she didn't really have problems. She was really driven. It was this older employee that was just manipulating the process, and that's who she was. She was evil. And that was the plan throughout the case. They're lawyers. They know the evidence, they know the facts, and they have so much information. And you've got to condense years of information into a few hours. You've got to explain to the jury why it has the value. And you got to get them to step into your client's shoes without telling them, step into client's shoes. And I think that that's what I do well.
So what was the total verdict delivered to your clients?
$7,990,000.